Assalamu alaikum. Advocate Ameer Hamza here with you. Today I will discuss with you Supreme Court of Pakistan, Appellate Jurisdiction, Bench 3rd, Mr. Justice Syed Mansoor Ali Shah, Mr. Justice Jamal Khan Mandokhail, Mr. Justice Athar Minallah. सिविल पटिशन नंबर 3472 3475 ऑफ 2023 इसके अंदर जो है कुछ सुपर टैक्स सेक्शन 4C को डिस्कस करा गया है. Syed Mansoor Ali Shah, Justice, through the present petition, the petitioner seeks leave to appeal against the order of the Islamabad High Court dated 8/8/2023, whereby it has an interim relief restrained the petition from recovery of the super tax under section 4C of the Income Tax Ordinance 2001 as amended by the Finance Act 2023, para 2, arguing against the legality of the impugned order. The learned counsel for the petitioner made two main contentions. First, that the High Court did not adhere to the mandatory procedure prescribed in Article 199 sub 4 of the Constitution of Islamic Republic of Pakistan Constitution for making interim order in matter relating to assessment and collection of public revenue. Number 2, that by making the impugned order, the High Court virtually suspended the operation of the legislation. Section 4C of the Income Tax Ordinance 2001, which could not have been legally done in sport of contention, she placed reliance on Federation of Pakistan versus Itazaz Hassan PLD 1989 SC 61, Ijaz Jatoi versus Liaquat Jatoi 1993 SAMR 2350, and Assistant Collectoral versus Dunlop India Ltd AIR 1985 SC 330. On the other hand, the learned counsel for the respondent submitted that the respondents challenge the amendments to section 4C of the ordinance through Finance Act 2023. On the extent of its retrospective applicability, he submitted that a similar challenge to the extent of retrospective of the unamended section 4C of the ordinance was read-down by the Islamabad High Court in its judgment dated B/7/2023, passed in Fuji Fertilizer. We have considered the respective contention of the learned counsel for the parties, have examined the record. Para 4, at the outset, it's important to note that the present petitioner challenged the interim order of the High Court, and we are fully cognizant of the establishment, practice and policy of the court, whereby it is not ordinarily intervenes in the interim order of the High Court. Such intervention is warranted only in exceptional circumstances, such as case involving a flagrant violation of law, a clear wrongful exercise of jurisdiction, or a manifest given justice. In the present case, the exceptional circumstance is the alleged violation of the constitutional requirement of granting interim relief under Article 199 sub 4 of the Constitution. Hence, the proceed to examine the impugned order on merit. Number 5, to appear the contention of the learned counsel for the petitioner, it would be expedient to reproduce Article 199 sub 4 of the Constitution for ready reference. The court shall not make an interim order unless the prescribed law officer has been given notice of the application and are only any person authorized by him in that behalf has had an opportunity of being heard and the court reason to be recorded in writing is satisfied that interim order number 1 would not have such effect as aforesaid. Number 2 would have the effect of suspending an order or proceeding which on the force of the record is without jurisdiction. A plain reading of the above provision show that where the making of an interim order would have the effect of impeding the assessment of collection of public revenue, the High Court shall not make an interim order unless number 1 the prescribed law officer has been given notice of the application for interim relief and he or any person authorized has had an opportunity of being heard, and 2 the High Court for reason to be recorded in writing is satisfied that the interim order would have the effect of suspending an order or proceeding which on the face of the record is without jurisdiction. Para 6. It is well established principle that where any provision couched in a negative language required an act to be done in a particular manner, then it should be done in the manner as required by the statute, otherwise such act will be illegal and without jurisdiction. 5. The use of negative language shall not in Article 199 sub 4 leaves no doubt that its provisions are mandatory and interim order passed without adhering to the procedure provided therein will be illegal and without jurisdiction. In the present case, it is an admitted fact that the High Court did not give notice of the application for interim relief and provide an opportunity of hearing to the prescribed law officer, the Attorney General, nor did the High Court record its finding and the reason therefore that the interim order would have the effect of suspending an order or proceeding which in the face of the record is without jurisdiction. Both the mandatory requirement of Article 199 sub 4 were not complied with by the High Court in making the impugned order, which failure makes these orders illegal and without jurisdiction. The present case thus involves a flagrant violation of law and a clear wrongful exercise of jurisdiction which warrants interference by this court in impugned interim order. We observe with respect that the High Court acted with undue haste in making the impugned interim order without giving notice and without providing an opportunity of hearing to the prescribed law officer. The impugned interim order suffer from this inherent vice and deserve to be set aside on this account alone. Para 7. For the above reason, we convert this petition into appeal and allow them the impugned order or set aside. The respondent application for interim relief shall be decided by the High Court after affording a fair and reasonable opportunity of hearing as envisaged under Article 199 sub 4 of the Constitution. The High Court shall also identify the order or proceeding under challenge the term of Article 199 sub 4 B2 of the Constitution. The High Court will also attend to the other contention of the learned counsel for the petition regarding suspension of legislation through the interim order in the light of the law cited by her, give that the matter pertains to the assessment and collection of public revenue We accept that the High Court will decide not only the application for interim relief but also the writ petition as expeditiously as possible. The Judge Islamabad 29 फरवरी 2024 for reporting. इट्स एंड ऑफ द जजमेंट। और ये एक जजमेंट थी सुप्रीम कोर्ट की, इसमें सेक्शन 4C को डिस्कस करा गया था, सुपर टैक्स। तो दोस्तों से रिक्वेस्ट है कि प्लीज़ इस जजमेंट को खुद भी सुने और दोस्तों को फॉरवर्ड भी करें, और प्लीज़ शेयर एंड सब्सक्राइब टू माय चैनल फॉर द मोटिवेशन पर्पज़। इट्स ए मोटिवेशन टू वर्ड यू फॉर मी। जज़ाकल्लाह। प्लीज़ सब्सक्राइब टू माय चैनल।